Hi everyone. On the 28th of October 2022, the government released a new bill titled the Criminal Justice, Incitement to Violence or Hatred and Hate Offences Bill 2022. In relation to this new proposed law, the gov.ie website states the following. The bill is designed to update laws criminalising hate speech and legislate against hate crimes for the first time in Irish law. The bill includes provision to strengthen protections for genuine freedom of expression. The bill includes a new list of identity characteristics protected under law. The bill is expected to become law before the end of this year. The bill is intended to criminalise any intentional or reckless communication or behaviour that is likely to incite violence or hatred against a person or persons because they are associated with a protected characteristic. The penalty for this offence will be up to 5 years imprisonment. The bill will also create new, aggravated forms of certain existing criminal offences like assault, coercion, harassment, etc., where it is found that those offences are motivated by hatred of a protected characteristic, such as race or colour. These offences will carry an enhanced penalty, and the criminal record will state that the offence was a hate crime. The bill includes for a demonstration test for hate crimes to make it easier to secure prosecutions and convictions for crimes allegedly motivated by hate. The protected characteristics in this new bill are race, colour, nationality, religion, national or ethnic origin, descent, gender, sex characteristics, sexual orientation and disability. Gender, disability, descent and sex characteristics were not included in the 1989 Act, and descent and sex characteristics have been added in more recent months following additional consultation with key stakeholders. The bill has been created to ensure that it captures hate speech in an online context, particularly in a social media environment. And finally, a quote from Minister Helen McEntee in relation to the introduction of this new bill. There are protections for freedom of expression built into this legislation, but ultimately, hate speech is not about free speech. Hate speech is designed to shut people down, to shut them up and to make them afraid to say who they are and to exclude and isolate them. There is nothing free about that, and there is frankly no place for it in our society. A person would be forgiven for thinking that Helen McEntee is actually talking about free speech, when she is talking about shutting people down, shutting them up, making them afraid to say what they believe and excluding and isolating them from society. Now we will take a brief look at the bill. The bill is split into 4 parts. Part 1 deals with issues such as definitions and the meaning of protected characteristics. Part 2 is the section that provides for a new offence of incitement to violence or hatred, which will replace the current law, which is the Prohibition of Incitement to Hatred Act 1989. Part 3 creates new, aggravated forms of certain existing criminal offences, where those offences are said to be motivated by prejudice against a protected characteristic. And Part 4 deals with amendments to other pieces of existing legislation, which will need to be amended as a result of the passing of this bill. Now we will take a brief look at Parts 1, 2 and 3 of the bill. Part 1, Section 2 is titled Interpretation. This section states that hatred means hatred against a person or a group of persons in the state or elsewhere on account of their protected characteristics or any of those characteristics. So, although this section purports to define hatred, it doesn't actually define what hatred is intended to mean. One interesting point to note is that the pre-bill, which was released earlier this year called the General Scheme Criminal Justice Hate Crime Bill 2021, did actually define hatred as meaning detestation, significant ill will or hostility. Part 1, Section 3 lists out all of the characteristics that will be protected under this bill and includes race, colour, nationality, religion, national or ethnic origin, descent, gender, sex characteristics, sexual orientation and disability. The majority of these characteristics are already protected under other pieces of Irish legislation, such as the Equal Status Acts and the Employment Equality Acts. However, this bill introduces a few new categories such as 1. Descent. Descent includes references to persons who descend from persons who could be identified by certain characteristics such as race or colour, but not necessarily all of those characteristics still exist. We have rightfully labelled this ancestral privilege because that is exactly what it is. 2. Gender. Gender is now said to mean the gender of a person or the gender which a person expresses as the person's preferred gender or with which the person identifies, and includes transgender and a gender other than those of male and female. And 3. Sex characteristics, which is said to mean references to the physical and biological features of a person relating to sex. Part 2, Section 7.1 creates a new offence of incitement to violence or hatred based on a person communicating material to the public or a section of the public, or behaving in a public place in a manner that is likely to incite violence or hatred against a person or a group of persons based on their protected characteristics. In relation to this section 7.1, 3 questions arise as follows. What is material? What is a public place? And what is behaviour? Part 2, Section 6 confirms that material is anything that is capable of being looked at, read, watched or listened to. A public place means any place to which the public has access. And behaviour includes behaviour of any kind, including things a person says or otherwise communicates, as well as things a person does, and such behaviour may consist of a single act or multiple acts. So to be guilty of an offence under Part 2, Section 7.1, you only have to display, publish or make available any material. This could be verbally, in writing or even gestures, in a place where the public has access, even if the public is not accessing that place at the time, and one single act is enough to breach this new law. Also, the threshold for this offence is intent or recklessness, which means that you can be prosecuted if you intended to incite violence or hatred, or if you were reckless as to whether violence or hatred might be incited. Part 2, Section 7.3 states that it will be a defence to this new crime of hate speech if you can prove that the material consisted solely of a reasonable and genuine contribution to literary, artistic, political, scientific, religious or academic discourse. That said, the following points should be noted in relation to this apparent defence. 1. The burden of proof is on you to prove that the alleged hate speech is not in fact hate speech. 2. This section 7.3 states that this defence will only be available where the material consisted solely of a reasonable and genuine contribution. In this regard, I expect that those prosecuting these types of offences will try to argue that while some of your speech may be a reasonable and genuine contribution, other parts of your speech were simply inflammatory, and therefore none of your speech is actually protected due to the inclusion of the word solely in this section. 3. Reasonable and genuine contribution in relation to literary, artistic, political, scientific, religious or academic discourse means a contribution that is considered by a reasonable person as being reasonably necessary or incidental to such discourse. And 4. What this means is that the courts will be employing the reasonable man test to determine if your speech is allowed. In this regard, I would suggest that you ask yourself how comfortable you are with the average person assessing or dictating what speech you can use, and also think about how the reasonable man or the average person would have assessed your opinions or treated you during the COVID-19 pandemic. The sentence for hate speech under this part is on summary conviction to a Class A fine, which means a fine of up to €5,000 or imprisonment for a term not exceeding 12 months. Or on conviction on indictment to a fine or imprisonment for a term not exceeding 5 years or both. Part 2, Section 8 introduces a completely new offence of condonation, denial or gross trivialisation of genocide, a crime against humanity or war crimes, against persons on account of their protected characteristics. Part 2, Section 9 states that a person may be found guilty of an offence under Section 7 or 8, regardless of whether they were actually successful in inciting another person to violence or hatred. Part 2, Section 10 creates a new offence of preparing or possessing material that is likely to incite violence or hatred. This section of the bill is seeking to criminalise people who create content that may incite violence with the intention of communicating it, but who have not as yet communicated it publicly. Part 2, Section 10.3 states that where it is reasonable to assume that the material was not intended for the personal use of the person shall be presumed guilty until they prove otherwise. The penalties under this section are on summary conviction to a Class C fine, so this means a fine of up to €2,500 or imprisonment for a term not exceeding 6 months or both, or on conviction on indictment to a Class A fine, so again this means up to €5,000 or imprisonment for a term not exceeding 2 years or both. It's important to note that these are the penalties for preparing or possessing material that might incite violence or hatred, but that you have not as yet communicated to anyone. The next section, section 11, is truly insincere and deceitful. Part 2, section 11 is titled Protection of Freedom of Expression. This section states that any material or behaviour is not taken to incite violence or hatred against a person or a group of persons on account of their protected characteristics or any of those characteristics, solely on the basis that the material or behaviour includes or involves discussion or criticism of matters relating to a protected characteristic. So this section 11 is purporting to state that discussion or criticism is allowed. The dictionary definition of discussion means the action or process of talking about something in order to reach a decision or to exchange ideas, whereas criticism is said to mean the expression of disapproval of someone or something on the basis of perceived faults or mistakes. It's worth noting that there was no similar protection offered in the pre-bill which was released earlier this year. As I said, the inclusion of this section 11 is truly deceitful, because one could be forgiven for assuming that the remainder of the bill is somewhat nullified, as most content can be described as discussion or criticism. That said, I believe that this section 11 was included in the bill to ensure the bill is passed by both houses of the Oireachtas. But you should be under no doubt that the Gardaí will entirely and wholeheartedly disregard this section 11 when they are contemplating prosecutions. I make this statement in the full knowledge that the Gardaí have already gone so far as to task themselves with investigating and recording non-crime incidents. Just to explain what this means, the An Garda Síochána website explains what a hate crime and a hate incident is. A hate crime is said to be any criminal offence which is perceived by the victim or any other person to in whole or in part be motivated by hostility or prejudice based on an actual or perceived age, disability, race, colour, nationality, ethnicity, religion, sexual orientation or gender. Whereas a hate incident means any incident which is not a crime but which is perceived by any person to in whole or in part be motivated by hostility or prejudice based on the actual or perceived age, disability, race, colour, nationality, ethnicity, religion, sexual orientation or gender. So the Gardaí are already investigating alleged hate incidents which are not crimes. This is the reason why I am saying that you should not take for granted that the Gardaí will pay any attention to this section 11 of the bill. Part 2, section 15 deals with search warrants and confirms that a district court judge can issue a search warrant of any place where evidence of hate speech may be located. This section confirms that the Gardaí may search any place noted in the warrant and any person located at that place. This section also confirms that the Gardaí may use reasonable force to enter your property, and they may examine, seize and retain anything found at that property, including documents, phones, computers, etc. Part 3, sections 17 to 20 create new aggravated forms of certain existing criminal offences, where those offences are said to be motivated by prejudice against a protected characteristic. So these sections 17 to 20 include for updated offences like damaging property aggravated by hatred, threatening, abusive or insulting behaviour in a public place aggravated by hatred, distribution or display in a public place of material which is threatening, abusive, insulting or obscene aggravated by hatred. This part 3, sections 17 to 20 update about 10 to 15 different offences in this way. The updating of these existing criminal offences in essence creates new categories of crime called hate crime. The net effect of hate crime is to create a hierarchy of justice, whereby a person who belongs to more minority groups will receive more justice. A simple example would be if a white person and a black person were both subjected to a physical assault. The perpetrator could receive a harsher sentence for the assault on the black person by virtue of their protected characteristic, which is their colour, than the white person, regardless of the fact that both the white and the black person sustained the exact same physical injuries. And finally, Part 4 amends other pieces of existing legislation which would need to be updated by virtue of the passing of this bill. I want to conclude this video with a message to the Minister for Justice, Helen McEntee, to the members of An Dáil Éireann who might contemplate supporting this bill, and to the immoral and weak bullies in our society who would seek to silence any opinion with which they disagree. How dare you think that you possess the right to define an emotion as complex as hate, and to impose your definition of this subjective emotion on the free men and women of this country? How dare you attempt to create a Marxist system of justice which completely disregards the fundamental idea that all men and women are to be treated equal before the law, in favour of a system which grants more or less justice to victims based on their immutable characteristics? Maybe you should consider the following question. How many world leaders throughout history improved the quality of life for their people by regulating their speech? Did Hitler improve Germany when he crushed dissent? Did Stalin or Lenin improve the Soviet Union? Did Pol Pot improve Cambodia or Mao improve China? I ask if any one of you in support of this human rights atrocity can give me the name of any world leader who crushed dissent and somehow improved that society. Were there not enough gulags and mass graves in the 20th century to persuade you of the dangers we now potentially face? Were there not enough books written and personal accounts recorded to penetrate your feeble minds? Either way, you need to understand what I am about to say next. Whether these disgusting laws exist or not, you will never take ownership of my mind or my speech, and I will never obey an unjust law regardless of the consequence. And I will remind those of you listening that the people creating these laws today are the same people who allowed your elderly loved ones to die alone. They are the men and women who destroyed lives and families. They are the establishment who stole from you your civil liberties and withheld them from you until you participated in an experimental gene therapy. These sick, power-hungry tyrants destroyed this country for a virus with a 99.98% recovery rate, and we are now to trust them to govern our thoughts and speech. As I stated earlier, the government have stated that they want this bill passed before the end of this year, so we do not have much time to act. I am therefore asking for your help in the following ways. 1. We are asking that you write to your TDs and senators, but not to beg them to vote no to the passage of this bill, but instead to advise them of the consequences of voting yes. We must tell these tyrants in no uncertain terms that any law which seeks to criminalise thought or speech will lead to large-scale civil unrest. In this regard, you will find a template letter in the description box of this video, which you may use and adapt as you see fit. You will also find a second document setting out the contact details for TDs. Please do not wait to send this letter. Please send it today if you can. And 2, we want to encourage members of the public to organise protests throughout the country, which the ICHR will be more than happy to advertise and support. The commencement of the erosion of free speech in 2019 is what made me go public with my views. I believe that free speech is the most important of all rights because it is the right that underpins all other freedoms, and I will not allow a tyrannical overreaching government to control how I think or speak. Some people may legitimately question why a government would seek to limit its citizens' rights to speak, criticise or offend. According to Joseph Stalin, the answer is persuasive. Stalin said, "Ideas are more powerful than guns. We would not let our enemies have guns. Why should we let them have ideas?" Now is the time to act. Thanks for listening.